Now back to the show. This is The Law Show on CL 650.
And welcome back to The Law Show on CL 650. Today we're talking about wills and estate law. And from McQuarrie LLP, we have Alyssa Lockhart, partner, and JC Wingson, QC and partner at McQuarrie LLP. And we talked before the break about undue influence. So I, as a layperson, look at this as saying, somebody's forcing the elderly person to do something that they don't want to do. Is it that simple? And can you give us some examples of what kind of influence? Can it be subtle?
It can be far more subtle. It can be that clear. A classic example like what you're talking about might be a child who says, "Mom, I'm not going to be able to come and take care of you every day anymore. I can't afford it, and I'm not going to be able to continue working. So I'm going to have to let you deal with your own self. And, unless, of course, I could have the house." So it could be that easy as a child simply laying it out financially for the parent. And the parent is fearing, how will I get to my doctor's appointments? How will I get to the grocery store? Or who will bring me groceries? What about the personal care that the child is performing?
But how do you say, okay, on one hand, yes, that might be undue influence, but the reality is that the daughter might not be able to afford to take time away. So how do you get the balance?
So, what the court has done is they've created or the legislation, a presumption, because I find the name undue influence a bit of a misnomer. It really, it makes somebody seem so harsh, so sort of,
evils.
Yeah, just totally their own personal agenda. And it may not be that case. So you may have, they say if you are in a very close relationship, as Alyssa described earlier, that's the kid who lives in, close to the parent or even with the parent, etc., who is the one who is able to attend to the parent's needs. That's a close relationship. And so they've said if you have such a relationship where you have the potential for domination, they're actually going to presume that there's undue influence.
So it's the opposite.
If you end up getting a gift from, and it's both while you're alive, while the person is alive, and it always had been there while the person was alive. But now WESA has made that big change to say, after somebody has died, if there's this great gift in a will to somebody who's been really close to you, we're going to have this presumption that they were unduly influenced to make that gift in the will.
Well, whatever happened in the eyes of the law, you're innocent until proven guilty. This is flipping it on its head.
Criminal law.
And that's the big change in our estate administration side with WESA, was that they flipped the onus on undue influence. So it's a big change for drafting purposes.
And so when you're going forward maybe with another family member to say, well, my sister really had influence over mom. Yes, I lived in Ontario. I couldn't be nearby to help every day, but so when you have the onus on the person to prove that they didn't have influence, what can they do?
So likely make sure that when mom or dad is doing their estate plan, that they see a lawyer who is experienced in that area, who can actually look, and when doing that interview, make sure you're not at the interview. I can't tell you how many cases I've done where the kid is in the room as the parent is giving instructions about the will, which should not be done. It's a big no-no. But how you can prevent that is you see that lawyer. That lawyer will put the plan in place. They will usually make sure that, if it's while somebody's alive, there will be a document showing that this is my intention to make a gift. Because the answer to the undue influence presumption is mom intended this to be a gift to me. So you look at two things for a gift is the intention and delivery. Delivery is there because here's
the money,
will, right? Or they've given the house to you or whatever. But the intention is what I need the evidence for. I need to look at that evidence with whatever side I'm on. I need to look to see, is there evidence of intention? And that's what Alyssa was talking about. The lawyers now always had very clear guidelines as to what they need to do when they're making an estate plan for someone. And nowadays, it's not just come in and do a will, as Alyssa was saying. It's got so very complex. Like, there are a lot of moving parts, and that's why Alyssa and her team, they tease through to find out what is it are you trying to achieve as opposed to what transaction you're doing. So they now have a responsibility to make sure when that person comes in, they see them alone, they ask questions to make sure there isn't that influence. If they know that is the child bringing you to the appointment, and that child is getting the bulk of the estate, they will tease through that and then make sure they have the documents that cover.
So how do you actually bring this up? Do you say, can you please excuse us? I need to speak to your mother or father alone.
Many times we'll actually, because we always run conflict checks before we open a file. So when my staff take a call from someone, they will determine who is making the call. And they'll take good notes about that. If the child is making the appointment, then my staff are very well trained to determine whether or not the parent can be capable of coming to the phone and
doing it themselves.
Booking their own appointment. We would like to speak with the client rather than the child. Sometimes the child is innocently calling because the parent says, look, I need a ride, and since you're the one with the schedule in the car, you book the appointment. That's completely fair, and as JC says, there's nothing intentional or overbearing about that, but it can be an indicia, one of the indicia of undue influence if all of the other pieces fall into place. So we want to keep a good record right from the get-go, and we make sure that clients understand that if they can get to our office under their own steam, or if a friend or if multiple children could bring them, that would be fine. But we always send the child away when they arrive. And this isn't something necessarily new to WESA. The flipping of the onus is, but I recall a very specific case over 10 years ago, prior to WESA, well prior to, I had a father and a son come in. They had a small farm tree operation. And the son had stayed on the farm and done a lot of work and developed a lot of equity. But the asset was all in the father's name. And I said, this is really unfortunate that you're both here. I feel that this will be challenged after passing. So I'd like to refer Dad out to another lawyer, and son, you can't go in. So it has to be Dad. Dad has to express his wishes, and you can drive him because he's not driving anymore. But make Dad, have Dad make his own appointment. Next week they called and they said, well, the lawyer insisted that I come in. He said, is your son here? I want to talk to him. And so at that point, I said, oh, that's very unfortunate. I don't support that approach to practice. There was a challenge after passing, of course, and that was a live issue on that trial, as I recall, that the son had taken him at that point to multiple lawyers. Well, no, Dad had taken himself to multiple lawyers, and I had sent him away in order to avoid the implication of influence because I had met with them both. So it's always been something that we're very concerned about.
And notes, right?
I was just going to say, Alyssa's raised a really good point about keeping a good record, even from the time of the initial call. I can't tell you how many times I've, because then if there's a challenge based on undue influence, what you want to make sure is that this will reflect the true free volition of the person making it. And so that is testamentary capacity. They're capable. They're not been influenced. All of those things. So we get the lawyer's file when there's litigation about whether there's been undue influence or not, and other types. And I look at the note that the secretary makes. I look at nowadays the will is being emailed to the child for the parent to review because, the parent doesn't have an email address in some cases. But if the child's now the one emailing back with instructions about what to change in the will, you're all of that evidence. So yes, it's really imperative to make sure you have not only a good estate plan, but a lawyer who's very familiar with all of this and who will make good notes to their file, because those notes are evidence for people in my side of the business. And, the lawyers often can be called to give evidence.
Now, we've talked about this before, the layperson's view, and we brought it up that you can't exclude somebody in your will. And this is this sort of urban myth that it keeps getting perpetuated. And I asked you, how did it start? And there is no answer to it. But a lot of people believe that the law in British Columbia is you can't cut somebody out of your will. And it's...
well, it started way back when. I think it was under the Spouse Protection Act.
Mm-hmm.
So when, usually men would have mistresses and they would make their will, and all of a sudden, wife and mother is left nothing, and mistress is getting all of this. So they started it as the Spouse Protection Act. And then it sort of morphed over the years and
began to include children.
Yes.
And now we have the Wills Variation Act, which very clearly includes spouses and children.
Yes.
But you
But
can't
in
set
other
up.
jurisdictions, for example, I had a matter where our the mum had lived actually back east, moved out here. Her daughters were living out here, just had 2 daughters. And she died in Abbotsford, but her family property was in Saskatchewan. One of the daughters is challenged, so we needed to bring wills variation. But because the property was in Saskatchewan, BC courts couldn't deal with it. So we had to retain a Saskatchewan lawyer. And their, what they call dependence relief legislation, is very different. You actually have to show dependence. So while both daughters could bring a wills variation claim here, only one daughter, the one who was
challenged,
could bring it in Saskatchewan.
Interesting.
Yes. Yeah. So,
but on the other hand, Alyssa, you've said that you can craft a will if you don't want somebody to get anything. You're maybe estranged from them to actually do that. But
you have to explain.
Yeah.
If you're gonna cut somebody out, you should, for example, if it's because of estrangement, or it could be because, you know what, I provided for that child quite generously during my lifetime.
And the others didn't
to the
receive,
exclusion
yes.
of the others. But you do need to, usually it's a memorandum that the lawyer would prepare that goes along with the will. And again, evidence for us, right? You're trying to determine, does this parent have a valid and rational reason, or spouse have a valid and rational reason for not making adequate provision in their will for the person who's seeking to get it varied.
And we've talked about it in the context of, for instance, my 3 children. If I looked at them and one of them was incredibly successful and was wealthy beyond the other 2, would it be fair or equitable for me to divide my estate in 3 ways? If the other 2 were struggling with mortgages and not able to enter the real estate market in the Lower Fraser Valley, and the first one, for instance, had 4 different homes and flew all over the world on vacation all the time, would it be equitable? So we can look at fairness, equity as separate and apart from equality. And so we definitely craft documents like that. But just like undue influence, it's all about documentation. When we look at the similarity between the 2, writing someone out and whether someone was influenced, I think when we talk about who booked the appointment, did the testator actually want a new will? Right? That's really at the crux of the beginning of that interview is who's making the appointment and why? Do we want a will? If we don't want a will, maybe we don't have capacity or maybe we're influenced. But when we look at, as JC said, capacity, I have on the 3rd or 4th page of my interview notes sheet a question, capacity. I don't answer that question with my clients until the 3rd or 4th page because I need 20 minutes to half an hour to talk with them to even assess whether they have, in my view, capacity, and sometimes longer. So when I see interview sheets that are four lines long that clients have brought in from other sources and they say, I just want this will, I don't think that represents a clear testamentary intent.
All right, we're going to take a quick break. When we come back, we're going to get into dispute resolution, procedural issues, dealing with executors. On The Law Show, we're talking about wills and estate law with Macquarie LLP next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.